Welcome to the Veterans Legal Lowdown. I'm Michael Lostritto, a partner here at CCK Law, and today I'm joined by my co-host, Alyse Phillips, a supervising attorney here at the firm. Today we're going to be talking in 5 different segments about avoiding VA claim and appeal denials. We'll be touching on unexpected VA technicalities that can lead to incorrect denials. We'll be talking about pyramiding generally and how it applies to claims, what the benefit of the doubt actually means and what it does not mean specifically, for what can be a good idea or when it can be a good idea and why to reopen very old denials. And finally, the last segment will touch on why older veterans should consider filing claims now. Before we get started, remember to like, subscribe, comment, and share. We always appreciate questions and the feedback. Has many rules, as we all know, and many of them are not that intuitive. But those rules and the complicated nature of applying those rules to individual claims should not work against veterans. After all, Congress and the courts have routinely said that the system is supposed to be veterans-friendly, non-adversarial. When in practice, sometimes we see these rules working against clients, it's important that we as VA-accredited attorneys and practitioners do what we can to advise our clients on how to avoid those denials based on technicalities.
Yeah, absolutely. And, one thing that I really want to talk about in this segment is starting with the initial claim stage, right? And specifically with form requirements, because a lot of veterans view the VA, and it is, a veteran-friendly system, but actually with the form requirements, you can't just write out your claim on a napkin, so to speak. You can't just write it out on anything. You actually, based on the regulations, one of those regulations is 38 CFR 3.155, must be using the specific forms that VA has prescribed for the specific types of claims. So that's a very important thing to do. Make sure that you're filing your initial claims on the right claims in order for the VA to accept your claims, frankly.
Exactly. And another aspect of that is timing, right? When to file the claim. And it's critically important because the time that a veteran files the claim oftentimes dictates the effective date that's assigned to that benefit. And the effective date that's assigned to the benefit therein dictates how far back VA will pay a veteran when they grant the claim and then pay retroactive benefits. And so the timing of when to file a claim is critically important. And we see this as a pitfall that veterans often trip up on as they're going about the VA claims process. There's something known as an intent to file form. And it's essentially a placeholder document that allows for veterans to file. And as of the date that they file the intent to file form, it preserves an effective date for any potential claim so long as the veteran finishes the process and files a claim within 1 year from the date that they file the intent to file form. And so sometimes we see clients come to us and they filed an intent to file form known as an ITF, and maybe it's from 2 years ago and they still want to file a claim in relation to that ITF. And, that's something they get confused about because in their mind, they filed that placeholder ITF, but they're outside the window now to actually file the claim in relation to that ITF to preserve that earlier effective date. Or veterans don't realize that they have the ability to file the ITF at all. And so, they either submit a claim and it could have been, they waited to submit the claim because they didn't have all the evidence that they thought they needed, or they needed to do more research, or they needed to reach out to the right person in their mind to handle the claim, when they could have a year earlier submitted the ITF, locked in the effective date, and ensured that they were going to get paid the most retroactive benefits possible. And we're talking about the difference of potentially thousands of dollars in retroactive benefits that could disappear for tripping up on not knowing exactly when to file those forms.
Absolutely. And another big area where we're seeing timing come into play is with when you can submit your evidence, right? So the evidence that you need to support those claims. And we're really seeing this become even more impactful now that we are in the Appeals Modernization Act, or the AMA, because in the AMA, you can select certain lanes, certain evidentiary lanes, and each of those lanes has its own unique rules. Some of those rules are if you can submit evidence at all, for example, in higher level review, you don't submit any new evidence. In other lanes, you can submit evidence, but there are very strict deadlines for when you're allowed to submit your evidence. For example, if you're in the hearing lane, you can submit evidence 90 days after you attend the hearing. These are specific rules, special to just the hearing, or to the lane that you select. So it's important to know these rules before you you select the lane, but also once you're in the lane to pay attention to them, because it really does impact your likelihood of success. If you can't submit evidence to support your claim, you're less likely to be successful in actually having that claim granted.
Yeah, absolutely. Another common pitfall that we see very frequently, unfortunately, just because of the complexity of the system that veterans are forced to navigate, is completeness of the submissions that are required from VA to claim, appeal, or even just submit regular responses for information that VA is requesting. Form and general submission completeness is a big issue. Anyone that has looked at a form from VA realizes that there are numerous small boxes you need to check off or not check off, fields you need to fill out or not fill out, areas where you need to recognize that, they're highly technical documents, things that need to be completed and done fully for VA to take it in, process the document, establish a claim in their system, and then actually work it and adjudicate it. And this is a big pitfall veterans fall into, because a lot of times they have the form 95% completed the correct way, but they forget to check off a box that says that this claim is in relation to compensation, for example, or they forget to include the date of the prior decision on a supplemental claim appeal form. Oftentimes, that's enough for VA to reject the form submission that the veteran is submitting. And not only does that lead to aggravation and delay, it can lead to outright denials. And a lot of times, veterans just don't really understand why their claim has been rejected, why VA is asking for more information, why VA is asking for them to redo the form that they already submitted. And a lot of the information and requirements for completing the form thoroughly and completely are, it's all fine print, right? So it's challenging. And a lot of times this results in veterans' claims and submissions being rejected on technicalities, not on the merit.
Yeah. And another area where we really see a lot of challenges for veterans is, after that initial claim period, it's when we are actually filing appeals. So if something was denied, or if your decision wasn't, granted to the fullest extent, you will appeal those. But we've talked about timing a bit, but I think it's worth mentioning timing again. Timing comes into play with these appeals again. There's deadlines set with appealing your decisions. Generally, it's a year if you're going to select a supplemental claim or higher level review or an appeal to the board. But it's important to take a look at those, the back page of those rating decisions or whatever the decision is. Take a look at what your appeal options are and how much time you have to file them. Because if you don't file within that prescribed amount of time, you have lost your effective date, which is something that we had on before. But yeah, it's important not just in the initial claim period, but throughout this appeal system that you continue to abide by those strict deadlines.
And it's not just deadlines to submit appeals. As you spoke about a little bit earlier, the deadlines for submitting evidence or knowing when you can and cannot submit evidence as it relates to different appeal options is critically important for veterans to understand and apply in their case. It's something we see veterans get tripped up on all the time. They try to submit evidence with a higher level review appeal. As you mentioned earlier, you can't do that. Or they submit a supplemental claim appeal as an example. and they don't submit any new or relevant evidence at all.
Mm-hmm.
And of course, that's a requirement. That evidentiary submission is a requirement with a specific deadline for doing so for filing that type of appeal option. So I know we hit on that before, but it's really something that we see veterans sometimes struggle with and or just forget how to submit things or when to submit things. And so keeping those deadlines in mind is really important.
Yeah, and they carry over right through that appeal stage, just like how our form requirements carry over. So we talked about the strict filing requirements for initial claims. There are also requirements for notices of disagreement. And if the wrong form is used, it could result in your claim being pushed back, them asking you to resubmit it on a new claim. It all goes back to what we've been talking about, this whole time, which is mistakes that are really based in technicalities that veterans need to be careful of, because it can result in losing your effective date or a denial, just like a catastrophic end to your claim.
Yeah, absolutely. And so I think the major takeaway here is from this discussion is that oftentimes veterans' claims and appeals are denied based on, obscure technicalities, form requirements, things that have nothing to do with the merit of the underlying case. And that's what can be so frustrating about these types of cases, is that navigating VA's rules often are just as important as proving the underlying case, and denials often arise from a veteran's failure to strictly adhere to all those procedural rules. I strongly recommend veterans reach out to a VA-accredited attorney, and they will be in a better position to understand these rules, apply them, and know when they don't need to be applied to a veteran's case, and navigate the process in a way that a lot of times veterans are unable to do so on their own. Pyramiding is something we hear a lot from veterans, and it's something that VA uses often to deny veterans' claims. Veterans will often hear something like, you cannot be compensated twice for the same symptoms. And that's where the explanation stops. There's no further explanation. Oftentimes, pyramiding is described in rating decisions. You can tell it's been copied and pasted into the rating decision. There's not a lot of rationale or elaboration that VA does to explain what it is and the nuances of it. And so it's important to understand the concept of pyramiding. It does have very real implications for how VA decides veterans' claims, but oftentimes there's more to it. And so the actual regulation is more precise. I think it's important that we take a look at that here to set the context for our discussion. It can be found in 38 CFR section 4.14. VA says that evaluation of the same disability under various diagnoses is to be avoided. In plain English, that just means that VA can't compensate the same manifestation, meaning the same symptom or functional impairment, more than once. But that does not mean that a veteran can't receive separate ratings for related and separate conditions. And that's oftentimes where VA gets tripped up.
Yeah. So I think the easiest way to think about this is to look at how, like you said, the manifestation. So how do these disabilities actually affect you, or what functional limitations are you actually seeing from these disabilities? And are they separate and distinct enough to be rated separately? So, for example, if you have two different eye conditions that both cause blindness, you're only going to get rated for the blindness once because it's the same result. So what's the result? Are there two separate results? Do you have, I don't know, an eye condition that causes problems with seeing light, and then another eye condition that causes problems with seeing in the dark? I'm just making things up at this point, but that's two different symptoms. But complete blindness, one symptom, it's all going to be rated the same. So really what you're looking at is, are the symptoms separate and distinct?
Yeah, that's a great way of thinking about it. And another common example that we see involves spinal conditions and radiculopathy. Spinal conditions are oftentimes seen in veterans' cases. They involve either an accident or some injury to the veteran's back, and that results in the spinal condition, which is then rated under VA's diagnostic code as based on limitation of motion. And so the veteran will receive a rating for any limitation to motion based on their spinal cord injury, but the spinal cord injury will also oftentimes result in radiculopathy, which is a tingling or weakness sensation in the veteran's extremities, limbs, arms, legs. That's a separate and distinct condition, even though it resulted from the back condition. And so in that example, yes, the veteran can be rated for his or her spine, but VA should not attempt to use the concept of pyramiding to deny a separate rating for the resulting radiculopathy. Separate and distinct conditions, each can be rated separately to help a veteran increase their overall combined rating.
Yeah. Another example, let's take mental health conditions and sleep disorders. So mental health conditions, we're also seeing some overlap with sleep disorders because they frequently do involve a certain level of insomnia. And our mental health rating criteria does contemplate sleep impairment. But not all sleep disorders end with just insomnia or whatever the sleep impairment is that's also rated by the mental health disorder. Some sleep disorders such as sleep apnea also include difficulty with actually taking in oxygen. So that's a separate and distinct symptom. It's a physiological symptom versus a psychological symptom. Those would be rated separately. A mental health disorder that rates someone's difficulty sleeping, and then also sleep apnea that would compensate for someone's inability to take in air or use of requiring a CPAP machine, for example. Two different conditions resulting in separate and distinct symptoms rated separately.
We also see issues involving traumatic brain injuries or TBIs and resulting migraines. Just as we were discussing before, TBI and migraines, they are separate and distinct conditions, despite the fact that they may all result from the same initial head injury. And so as a result, VA should be rating them separately. They each have their own diagnostic code that contemplates different functional impairments, going back to what you were talking about a little bit before. For example, TBIs are rated under Section 4.124A Diagnostic Code 8045, and migraines are rated under Diagnostic Code 8100. And so each has its own diagnostic code, which allows for separate ratings, again, despite the fact that, maybe they both resulted from the same head injury in service, or that even the migraines resulted later from the TBI. And so, any attempt that VA may make to group those together and rate the condition as a single condition is essentially depriving the veteran of the benefit of having two separate conditions rated separately. And that's something you want to look for, appeal if necessary, but certainly call VA out on it.
Yeah, absolutely. I'm glad that you brought up that example because it's a good one. Both have they seem like similar conditions, or they're very similar in that they're impacting the head. But they're resulting in different symptoms, which is the point of pyramiding. And we want to make sure that each symptom that, somebody has its own box. So the cognitive impairments that we see related to a TBI, they have their own box. Those symptoms should be rated. And then we also have people with very severe migraines. They might not be able to function when they're in a migraine. That's a separate symptom that needs its own box that needs to be rated. So even if they're from the same occurrence, they happen from the same accident, they both have to do with the head. What we're looking at is the symptoms, not just the conditions themselves.
So to recap this segment, if a claim is denied based on pyramiding, a veteran should really look at three different things. The first is whether the symptoms are actually identical, therefore invoking properly the pyramiding statute, or whether they're just simply related, going back to the TBI, the migraine example. The second is, do the conditions have separate diagnostic codes and separate rating criteria? If there's separate diagnostic codes and separate rating criteria for the two conditions, it's likely that veterans can get separately rated for each condition, and VA, if they combine them into one, is doing so improperly. And the third is analyze the functional impairment caused by each condition individually. Again, if there's overlapping functional impairment, that's where you might run into issues with pyramiding. But oftentimes, the conditions will have separate and distinct functionality or impacts on functionality, and those impacts should be rated somewhere in VA's diagnostic criteria to compensate the veteran for the full array of all their symptoms deriving from those different conditions. Given how technical and complex pyramiding can be, don't be afraid to reach out and ask for help. If you would like more information on any of these topics or other topics, please feel free to reach out and take a look on our website. Many veterans know that by law, VA must provide veterans with the benefit of the doubt for their claim if there's evidence that can support and also evidence that can deny their claim. What that means in practice, though, is a bit more complicated and nuanced, and veterans often are confused by how that applies to their individual case. For example, some veterans come to us, I hear this all the time, and they have been led to believe that if their claim is merely plausible, VA has to provide them with the benefit of the doubt and grant their case. That's not technically how the rule is applied. So in this segment, we're going to explain what the benefit of the doubt actually is, how it's applied, what it's not, and how it can be useful to advocating for our clients.
Yeah, so the benefit of the doubt rule comes from 38 USC section 5107B and 38 CFR 3.102. Really what that rule is that when the evidence is already in the approximate balance, the benefit of the doubt goes to the veteran. So that means that when the positive evidence and the negative evidence are basically the same or roughly equal, VA should kind of tip the hat over to the veteran, weigh the evidence in favor of the veteran. So the evidence has to meet that equal level for the benefit of the doubt to actually come into play.
Yeah, and for years, veterans have been led to believe that this rule means there has to be a strict 50-50 split in terms of favorable and unfavorable evidence. But it's really not the case anymore. And the evidence doesn't have to be exactly perfectly equal for this rule to apply. A veteran could have, 51, 49%, or something that is the approximate balance of weighing the evidence, and the rule could still apply in their favor. And so it's really important that veterans know that if evidence supporting the claim is about as persuasive as the evidence against the claim, yes, the veteran should, in theory, win the case.
And it's tricky because in order to even get to that 51-49, VA needs to weigh the evidence. And to do that, they need to determine what evidence is persuasive, what evidence is less persuasive, which becomes, it's difficult to figure out how they've weighed the evidence. It's difficult to challenge it, but I'd like to try and talk about it for a little bit. Let's first hit medical opinions. We know that VA is going to put a fair or great amount of weight on the medical opinions that they get from their own experts. But Mike, what do you think? How did they weigh medical opinions from private examiners?
The key is the rationale that's used in the medical opinion and how it's laid out, how it's interwoven with the facts of the case to support the ultimate conclusion. A one paragraph or a one page letter from a doctor that just states a bunch of conclusions, doesn't examine the specific facts of the case, it's probably not going to be all that helpful, actually. And so just because it was, the letter or the opinion was written and signed by a medical professional, if the underlying opinion isn't supported and well supported, and there's not, probative evidence and value to the opinion, then it's not going to go very far in the veteran's case. We've seen examples where, VA has come out with a VA examiner opinion, CMP exam, and it doesn't happen often, but sometimes they're, detailed and well supported, and the veteran doesn't have any medical evidence to rebut the opinions from that VA exam. Maybe they have a lay statement that they've produced, but it's not supported by any of the medical evidence in the file. Just because they have evidence on the other side to prove their case doesn't mean that, the the evidence is in the approximate balance in favor of the veteran. It really gets into the type of evidence, how the evidence is produced, what it looks like, whether the opinion is well reasoned, and that will have a lot to say as to, how far the case goes and whether this doctrine can be applied. Again, it's not just a matter of having evidence on either side. VA has their evidence and the veteran produces something to counter it. It's what is the quality of that evidence. And so if VA has a strong medical opinion of their own and the veteran doesn't come forward with their own evidence that's equally supportive, the benefit of the doubt doctrine may not actually apply.
Yeah, it's a great point. Making sure that private exams don't just have a conclusion, but are well supported by the medical evidence, it goes a long way. But you touched on lay evidence, and I do want to talk about that because that is another type of evidence that can contribute to the weighing of the evidence overall. Lay evidence, it might not be able to rebut a medical opinion, but it does have its own value. It really comes down to the competency of what that lay statement is. So what I mean by that is VA cannot dismiss a lay statement just because it is a lay statement. So they can't dismiss something just because it came from a doctor. Because people, whether it's the veteran or family members of veteran, can testify to certain things. They can testify to things that are observable symptoms that don't require medical knowledge. So, for example, if we're talking about a psych condition, someone can say that they feel uneasy without having to diagnose themselves as somebody who has anxiety. So really, it comes down to the competency. Can the person who's making the lay statements report to observable symptoms? Are those symptoms going to help go towards the evidence, the weighing of the evidence, in favor of the veteran? So someone saying that they feel uneasy and they've felt that way since service might undercut or help to undercut a medical opinion that says there's been absolutely no symptoms since service, for example, because somebody can testify to their own symptoms, so long as they're something of that nature, that observable nature.
Yeah, and the absence of medical evidence in the file shouldn't be treated by VA as being negative evidence in and of itself. And so, as you were saying, lay statements often serve an important critical role in gap filling the record. Right. There's nothing there in the record medically documented, but that doesn't mean that there can't be evidence provided via a lay statement to help fill that gap, build the narrative, and ultimately win the case.
Yeah.
So I think the key takeaway on the benefit of the doubt doctrine is essentially that it is real, it's a thing, it's in VA law, both in regulation and also in practice, but it's not automatic, right? And a lot of veterans come to us and they say, well, the benefit of the doubt doctrine applies in all these situations, and therefore I always win my case. And it's clearly not that simple. It's important for VA to gather all the relevant evidence, lay evidence, medical evidence, treatment records, whatever it might be. So it's therefore important for us as practitioners to make sure all that evidence is in the record for VA to consider. VA must weigh the persuasiveness of all that evidence, both favorable and unfavorable. And only if the evidence is in approximate balance will this doctrine apply and therefore benefit the veteran and hopefully result in a grant of benefits. All right, let's shift to something we see, I would say, pretty regularly, right? It's instances where veterans filed a claim decades ago, perhaps the 70s, the 80s, the 90s. They were denied and they never did anything with the denial. They never appealed. They never did anything with it. The question becomes, well, what should they do with it? Can they do anything with it? And oftentimes the answer is it is worth revisiting the claim because situations and circumstances, the law, the evidence, it often changes as time goes on. And so the mere fact that a claim was denied a long time ago shouldn't really preclude a veteran from taking a look to see whether they want to reopen the claim. And to do so often requires new and relevant evidence. But as I was saying, that new and relevant evidence can many times be developed over the course of the preceding years after an initial denial.
Yeah. And I think one huge thing to consider is just that this is kind of the nature of how science works, right? So over time, our medical understanding develops. We have new studies. We have new exploration. Exposures are better understood. Diseases are better understood. New medical literature comes out. And all of those reasons are why it could be worth it to revisit a claim, right? Because something that you might have had denied years ago might now be understood as something that was caused by an exposure that you had in Vietnam, for example. That is the basis for the PACT Act. We see many different conditions that are now presumptively connected, service-connected, from exposure to Agent Orange or from exposure to burn pits that previously were not accepted as being connected in any way to service. So things change, science develops, and that's one reason to revisit your claim.
Yeah, and there are opportunities today to obtain medical nexus opinions that were not as accessible or veterans didn't know existed even 5 years ago, 10 years ago. Certainly not for claims that were denied back in the 70s and 80s. A medical nexus opinion is a medical opinion provided by a medical provider after a thorough review of the veteran's claims file. And it essentially, where they're able to, it establishes a link between some in-service component in the veteran's past to a current disability. And that medical nexus opinion goes a very long way in the VA world to helping prove service connection in a veteran's case. And again, so, these things, there are many providers now that weren't providing opinions for veterans back decades ago. And as you said, the science has evolved. And so perhaps the same provider 15 years ago couldn't provide a favorable opinion for the same condition that the veteran is now continuing to pursue then, but they're able to do so now because the science has changed. The literature has changed. And so it is oftentimes worth looking critically at old denials to see what else can be done.
And these new medical opinions can be enough to qualify as what we call new and relevant evidence to reopen a claim. So new and relevant evidence, it's not an overly strict standard, I want to note. The evidence just needs to have a reasonable possibility of substantiating a claim. So it does not need to prove your claim, but it does need to somehow meaningfully contribute to the possibility that it could potentially be granted. And a new medical opinion would qualify in most cases, I would imagine. Absolutely,
it would definitely qualify. Another thing that would qualify are kind of the continuity of symptomatology or the progression of symptoms over time. And as I know we have both seen in cases, veterans have no doubt experienced, symptoms often become clearer and unfortunately a lot of times worsen over time. And so that will lead to veterans in many cases seeking treatment today that they didn't seek 10, 20 years ago. The availability of treatment is, I would say, arguably greater today for veterans than it was back then also. Just the knowledge that these conditions potentially could be related to something that the veteran experienced in service oftentimes is reason in and of itself for a veteran to seek out some treatment that they once thought, what's the purpose? I'm just going to suffer. I'm going to deal with it on my own. I think there's been a great advance in educating the veteran population in the past so many years to show them that there are other options available to them. And so the progression of symptoms that didn't exist back then often will lead to it being worth a veteran to take a look at their old denied claim to see what could be done now.
Yeah. Another area that's progressed and evolved is the law itself. Veterans law, it has evolved significantly since the 1980s. The United States Court of Appeals for Veterans Claims, it didn't even exist before 1988.
Yeah.
It's younger than a lot of the attorneys at this firm. So the law is constantly evolving. It's still being tested. Things are changing. like I've said, not just with the science, but also with the law, we're now in a totally different appeal system than we were originally. We're in the AMA, as we've touched upon. And we use a new and relevant evidence standard, which is a new legal standard than what we used in the legacy system. So things change, and it's another reason why it's worth it to take a look.
So I guess in summary, if you're looking at an old decision and you want to know whether it's worth it to try to reopen that old decision that denied benefits based on the new and relevant evidence that you were speaking of, I think the key question is, well, what's changed since that decision, right? Like, what has changed since the time of that denial? And oftentimes it's all the things we've talked about. Symptomatology has changed. The access and availability of new medical evidence through a medical nexus opinion is now there, where it was not once available. The law oftentimes changes too, as you were just speaking of. There are new presumptions. And so all those things combined often will provide an avenue for veterans who, once were denied, can now reapply and potentially get benefits granted for the first time. So a lot of veterans who have been out of service for a long time just assume that, well, they've neglected perhaps filing a claim for a long time. They never got around to it. They never did it. They didn't think they could. And now a lot of time has lapsed since they left service, and they don't think they can. Mm-hmm. The good news is that when it comes to VA disability compensation benefits, legally speaking, there is no statute of limitations for filing an original VA disability claim. That means there's no time limit. Some veterans file the day after they get out of service. Some don't file until they're in their 70s or 80s, and we see both regularly here at CCK. These rules come from governing statute and regulations, which I won't get into, but the basis is there clearly in law for the fact that veterans can file an original disability claim for service connection benefits at any time. And so the mere fact that you may have waited for months, years, decades to file a claim should not discourage you. There is still time to file a claim if you think you have a claim that has merit.
Yeah. And I think a very common misconception is that it will be harder to prove your claim, which so long as you have the evidence that you need to show, we'll say, service connection, it doesn't matter how old the evidence is. So you need to have a current disability. You need to have evidence of an in-service injury, event or illness, and you need to have a nexus which connects the two. So long as you have that, it really doesn't matter that the evidence came from 40 years ago, 50 years ago, 60 years ago. It's just as, it holds just as much weight as somebody who files right after service. So another thing I wanted to note too is that you don't even have to be diagnosed during service. You can receive your diagnosis later, so long as we can still show that there is a current diagnosis, an in-service event, injury, or illness, and then nexus. So if you don't have a diagnosis during service, it's not something to sweat about, so long as we can show something in service led to it, to that later diagnosis that you now have.
And as we see all the time, the law continuously evolves and frankly expands as VA benefits and the system of VA benefits evolves over time. Many people in this area have heard about the PACT Act. I'm sure a lot of our veteran listeners and clients know about the PACT Act, but that's a prime example of an expansion of VA benefits that only 10 years, less than that even, didn't exist. And so, veterans who are in their 70s and their 80s perhaps, who have never filed a claim, though they may have wanted to for a long time, maybe the law back then didn't support their claim actually, right? Mm-hmm. But now, through the expansion of VA benefits and new presumptions that have been granted based on both location of service and types of condition and types of exposures, those benefits are now there within grasp for people who have never filed before. So veterans should not allow the fact that they did not file immediately after getting out of service dissuade them from wanting to file or being able to file now. Remember, there's no statute of limitations, as we said, and they can file at any point.
And then there's the practical reality that is, as people age, conditions tend to get worse over time. This is particularly true with conditions that are progressive. So we'll see that with an orthopedic condition, hearing loss, or maybe a certain mental health condition. These conditions tend to get more symptoms and more severe symptoms as time goes on. The reason why that's important is because how severe your condition is directly ties into what your rating would be. So maybe a condition that you didn't see as severe when you first got out of service, maybe a mental health condition that was resulting in a little bit of anxiety or irritability, is now kind of completely taking over your life. Maybe you didn't think it was worth it at the time to file, but now it really is something that you think you should do. It's another reason why, as your conditions get worse, it's important to look into filing. It's important that you're receiving the compensation that's due to you. And you might be getting higher benefits than you would have now than if you had applied previously.
Yep, absolutely. So the takeaway for older veterans is don't assume it's too late, right? It's not. And so oftentimes, as we've just laid out, not only is there no deadline, but it can sometimes advantage the veteran to file a claim now as compared to years ago, when perhaps the law at that point didn't support their claim, but it does now. Evidence can be built up over time, and new evidence can always be developed. So again, just because an older veteran didn't file years ago doesn't mean that they shouldn't examine whether they should file now, because oftentimes they can, and filing can often lead to a grant of benefits for them. And so that's our episode for today. Thanks for joining us on the Veterans Legal Lowdown. As always, if you like the content that we shared today, please like, subscribe, take a look at our website, cck-law.com, and we'll see you next time.